All right, let's get some legal analysis now on two High Court rulings. Today, legal expert Ulrich Roux joining us to talk about what we've just been discussing. Ulrich, good morning to you. Good to have you with us here on eNCA. Can we talk about Jacob Zuma's court case? First of all, back in the Pietermaritzburg High Court, which is then going to be in the Constitutional Court again next week. Forgive the ignorance. Help me understand, why are we back in the High Court if the former president's already in prison and it's the Court who sent him to prison?
Hi, good morning, Gareth. Thank you for having me. Yes, certainly it is an interesting scenario that the court finds itself in now. Remember that the application before the Pietermaritzburg High Court was an application to stay the execution of the Constitutional Court order handed down last week, Tuesday. So it was an urgent application launched by Jacob Zuma in an attempt to stay out of jail, effectively. So in an attempt to force the police commissioner and the Minister of Police not to execute the warrant of arrest that was issued. And remember that they had to execute that before 12 o'clock on Wednesday evening, as per the Constitutional Court order. Now, as we all know, Jacob Zuma eventually, minutes before the deadline, handed himself over voluntarily to the police, and he has been incarcerated since late on Wednesday evening. So effectively, that application launched on Tuesday is moot in that sense, in that he has already handed himself over and he's already started to serve the sentence. What is interesting, though, is that the urgent application had a Part A and a Part B. The Part A sought the relief that I just referred to now, that he should not be arrested and that the warrant of arrest should be stayed pending the outcome of the Constitutional Court rescission application, whereas Part B is an application whereby he seeks the court to declare the part of the Criminal Procedure Act unconstitutional, which allows for a person to be sentenced to imprisonment in contempt of court proceedings if he has not been granted an opportunity to adduce evidence in mitigation of his sentence. Now, those are a lot of terms that I refer to now, but basically he's saying that it should be unconstitutional that a person can go to jail without being given an opportunity to say to the court, well, you should send me to a shorter period of imprisonment or to no imprisonment whatsoever. The argument against that, obviously, by the Commission and by the Ellen Suzman Foundation, is that Jacob Zuma was granted numerous opportunities, 6 opportunities by either the Commission of Inquiry or the Constitutional Court to state his case, to state his defense against the allegations of contempt of court, and to adduce evidence in mitigation of sentence to show that he should not serve a period of imprisonment. So an interesting judgment today in that respect. You're always cautious to predict as to what the court is going to say, but obviously I think that the court will find that Jacob Zuma in the first instance had no right to approach the High Court, because the High Court cannot say to the Constitutional Court how an order should be stayed or implemented. And secondly, I think that Part B of the application is also going to be dismissed, given the fact that Jacob Zuma was granted so many opportunities to state his case, and he just bluntly refused to do so.
Acting on behalf of the Commission as well, I was reading, Ulrich, that the attorneys in that case, the advocates in that case, legal representation, saying that the former president knew he could have approached the Court to appeal their judgment as well and not go the High Court route. Can we move away quickly from the Jacob Zuma court case and talk about Magashule as well, fighting the suspension of his from the ANC and this resolution of step aside within the ANC? It's the High Court in Johannesburg that's looking at that particular court case as well. And they've got to be careful how they handle this, don't they, the courts? Because if they uphold this suspension, it could open up the floodgates for other political party members to come before court as well.
Yes, exactly. And it is a very interesting question of law that the court needs to apply. And that is obviously that all South African citizens are deemed to be innocent until proven guilty. And that is what Magashule is saying. He's saying that this step-aside policy of the ANC is constitutional towards unconstitutional towards his rights to be presumed innocent. He's been forced to step aside in light of allegations leveled against him of fraud and corruption, etc., etc. But he's saying that he cannot be forced to step aside until a court of law finds him guilty on those allegations. So, it's not the popular opinion, but I do think that he has a foot to stand on in that regard. Remember that all laws in South Africa and all policies and procedures adopted must be in line with the Constitution. And if it is contradictory towards the Constitution, then it should be set aside. So, that is exactly his argument. He's saying that I cannot be forced to step aside because I've not been found guilty of anything whatsoever. Yes, there are allegations that have been leveled against me, but the ANC is acting inappropriately in forcing me to step aside because I still intend to prove my case in court and to prove my innocence. There's obviously numerous opinions regarding that, but it would be interesting to see how the court applies that fundamental constitutional right of a person to be presumed innocent until proven guilty.
Going to be a very busy day for you, Ulrich Roux, suited up, tied up, and the fire crackling in the background as you follow these big 2 court cases for us. And I'm sure we'll be speaking to you again here on eNCA. Always a pleasure. Legal expert Ulrich Roux joining us here on eNCA.